welcome to the Our View Listening podcast. This podcast is an initiative of the India Arbitration Group of ICC India. My name is Abhisaar, your host for the day. I'm an advocate practicing in New Delhi, and I'm also a member of the coordination team at ICC IAG. This is a podcast where we dive deep into the world of arbitration. It is a series dedicated to bringing diverse perspectives on arbitration for practitioners across the globe. Whether you are a seasoned practitioner or just starting your journey in arbitration, this podcast will offer you insights from top experts in the field. As we would discuss the life cycle of an arbitration, one episode at a time, this podcast will help you navigate the complexities of arbitration. So whether you are here to expand your knowledge or simply to stay updated, RBU Listening is your go-to source. Today, the topic of discussion is choosing the right expert in arbitration, discussing the strategy, timing, and challenges. So joining us today as the guest speaker is Mr. Matthew Secomb, a noted lawyer in this field. Mr. Matthew represents clients in international arbitrations. Recognized by Lexology Index as top tier and widely recognized as a standout practitioner in the field, Dr. Matthew is known for his sharp advocacy. Clients and peers alike describe him as exceptional written and oral advocate and a thoughtful leader in cross-border cases. Thank you so much, Dr. Matthew, for joining us today, and it's an absolute pleasure to have you here with us. And our moderator for today is Ms. Abhisaar Bairagi. Ms. Bairagi is a partner at Khaitan Co. in the Dispute Resolution Practice Group. She practices corporate and commercial litigation and arbitration across a wide range of sectors, with special focus on infrastructure, construction, logistics, and many more. Ms. Bairagi represents both Indian and international clients on complex domestic and international matters across various forums, such as Indian courts, various high courts, and tribunals. Thank you so much, Ms. Bairagi, for joining us today, and it is indeed our pleasure to have you here. And with this, I hand over the stage to both of you.
Thank you, Adya. Such a pleasure to have you here, Matthew.
Pleasure to be here, Abhisaar, please.
So without further ado, for our listeners, so if you've ever been a part of a technical or construction arbitration, then you've shared your table with engineers, scientists, tech bros, finance bros, surveyors, scientists, and I don't know, so many other people who've been called upon as expert witnesses, right? And most legal regimes, including India, and most arbitration institutions, they do provide for appointment of expert witnesses. But what they do leave out is, after telling us about the appointment, much of the architecture of how to go about it, and this is all reliant on practice rather than prescription. So today, to discuss all these practicalities, including who to appoint, when to appoint, why should we appoint them, this is where we are going to lean on Matthew for all the tricks of trade and make him tell us all the secrets. So just to start off, Matthew, just a bird's eye view, we'll start off at 30,000 feet. Why does it become so crucial to technical and, say, construction arbitrations to have expert evidence? Is it because it simplifies complex issues, or do you think it just gives the tribunal something to rely upon?
Thanks, Abhisaar. I mean, it's a very good question. I think that, to start off with, we have to remember that arbitration is fundamentally an adversarial procedure. And each side just wants to win, and that's perfectly legitimate. Right. And at the end of the day, for the most part, each side views using expert opinion as a path, as a kind of a tool to winning their case. But of course, what that means in any given case depends on the subject matter. And one of the interesting things about expert evidence is, though it is one kind of genre of evidence, it actually has incredible variety. You have everything from kind of scientists right through to economists, accountants, and then you have some types of professional experts who kind of have a particular trade that is kind of useful in certain types of arbitration. So a very good example that you mentioned before was in the construction field. So there are certain types of things such as delay experts who deal with what happens when a project is delayed or who is responsible and to what extent for certain delays. And then the kind of the quantum or damages part of construction. You have these people who, deal with literally counting bolts and screws and deciding how much should be paid for certain works. And so, I think one of the interesting things about expert evidence in international arbitration is just the broad variety of things that you could potentially try to prove through the use of experts.
That's perfect. That's perfect. So let's talk about choosing the right expert. What is the real qualification? And I find myself asking this a lot of times, that are we looking at the real expertise, or are we looking at somebody who can survive and sit through a cross-examination?
Choosing experts is hard, and it's hard for a number of different reasons. Because the actual skill of an expert or good expert, it has to have both the kind of the subject matter expertise,
Right.
but also kind of a very specific set of skills. On the subject matter expertise, that can be, whatever the subject matter is. So, for example, in a lot of fields for product liability, sometimes in, construction or engineering things, you have kind of this concept of, say, root cause analysis. So basically, if there's a problem, what was the actual underlying cause? That's a very technical thing. But it could be an expertise in terms of the types of things we discussed before. Now, that's just part of what you want. You do want the expertise. But even that, it breaks down into two things, because there's the actual expertise, and then there's the perception of expertise. Because obviously people do look at people's CVs and they do care whether they have the right qualifications. But that's just one part. The other part is actually the role that they have to play. And people do get very excited about hearings, because obviously they're a focal point for the arbitration, and they're the point at which the expert is kind of put under stress because of the cross-examination that they will face, or the hot tubbing, which we might talk about later. But I think that something perhaps even more important is their ability to write properly. And I think that, I sit as arbitrator fairly frequently, even though the majority of my work is as counsel. And I think that the most important thing about an expert is the written material actually that they produce. And particularly for highly technical things, one of the great challenges is that the expert is a scientist or an engineer or what have you, but the target audience, the person to whom they're writing, usually is a lawyer or a series of lawyers who are sitting as arbitrator. So one of the great challenges is to take a very complex thing that the expert knows extremely well and to simplify it in such a way that lawyers who are not technical experts can not only consume them and understand them, but also be persuaded that the expert is right. And that ability to write well is, I think, one of the perhaps underestimated skills of an expert, and something that we certainly look to establish before we take an expert on.
That makes so much sense. Okay, now let me ask you a question. And again, I'm asking you because this is just coming out of personal experience. Because a lot of us, especially in this part of the world, we end up dealing with clients who were going into complex arbitrations for the first time. They're dealing with these kind of technical issues for the very first time. And especially, even in terms of construction arbitrations, and we tell them that you really, really need an expert in this case. And they would say, but why do I need an expert? My delay is writ large, it's palpable, my bills are all there, everything's on paper. And I really don't see why do you need a third person to say this really happened, this indeed happened. And who can deny it? And this is all undisputed, and why do you need it? So if you ever face a client like that, or if you ever get a client like that, where do you start off? How do you try explaining to them that why do they need an expert?
Yeah, no, well, I think, that's a challenge that I too have faced, because obviously, arbitration can be costly, and then you add the cost of good experts on top of them. And I would say not just that they have an expert, but they pay to get a good expert, because obviously, there are a lot of people in different disciplines who will do the work, but whether or not they're actually good is very different.
Right.
I think that the convincing a client to use an expert, I usually come back down to brass tacks. And there's two things: either if you're acting for the claimant and you have the first determination of what discipline of expert you will call typically, I think you ask the question, do you want to win this case? Because it's very nice for them to have a witness statement saying, to pick up your example, to have a witness statement from their head engineer or the project manager saying, look, these guys, the other side were bad, they delayed the project because they didn't give me access to the site, or they changed this or that. But that's not objective. By definition, as much as a witness should tell the truth, question whether they always do, but let's say witnesses should tell the truth. That's different to having somebody come in who is a skilled engineer who looks at things with a degree of objectivity. And you do need to explain to clients that sometimes, especially in those fields where they're really marshalling and repackaging evidence, the role of independence is important. And you actually, that independence can actually be a very persuasive element. So for example, if a delay expert gets some extension of time claims from the party who they've been retained by, and actually says, I know that you claimed these 10 days, but I don't think that's justified, but I think that 90% of the claims are justified. The fact that the independent expert kind of did not accept all of the claims prepackaged by the party that appointed them can actually be a very powerful thing, because the arbitrators start to have greater confidence in their credibility. And so that's the type of thing you need to explain to clients. Not necessarily easy, though.
No, that's actually a very great way of looking at that. The real test of independence probably would then be that if this person had actually been appointed by the other side, would they have reached the same conclusion? And the moment they start, differing from the person they sent their invoice to, and it you're right, and because you've donned that hat of an arbitrator, you'd be able to tell me better. But yeah, from my perspective too, as a counsel, I think that should give a lot of confidence in what they have to say, right?
Yes, but that said, it's funny because that's one of the things. So this is kind of the extension of the challenge you spoke of. When you start to have meetings with an expert, with a client, where the client is kind of explaining to the expert on what happened, often the clients are surprised because the expert is pushing back, even when you're at the drafting stage, saying, listen, you're claiming this, but this doesn't quite make sense, because I don't see how this element of the work actually would have delayed the critical path as compared to just simply being, for example, something that was disruptive. And often the clients are like, well, what am I doing? I'm paying you. And you have to explain to them, this is not a normal client relationship, that there is this independence element, which is different. And it can be frustrating for clients. So I think, you have to educate them about that.
True. While we are at it, and I think I wanted to ask this later, but I must ask this right now, that how do you, when you sit as an arbitrator, because we faced a situation where we had an expert and the other side did not bring an expert. And when the expert really did not align with everything that our client wanted to say. He really deviated, and we weren't really happy about it. But the tribunal was still a little reluctant to accept everything, because they said that that's the only expert in the room, and he's being paid by you. So when you're sitting as an arbitrator, how do you deal with the bias? One thing that you said was that if it is deviating, then obviously that this is not a biased opinion. But what if we have evolved and we start thinking of that also as a strategy? So we go far right, and then we say that you just deviate a little to the left, and then probably we'll deviate and everybody will come out happily. So how do you deal with that in general?
Yeah, I think that the thing that you need to remember and keep in mind when you're sitting as arbitrator and facing experts is that very rarely is it a process of kind of what I would call argument by authority, where the expert just simply says, I think this is right.
Right.
What it is, it's a reasoned opinion. And as soon as you add an element of reasoning where the expert says, I think that this is the outcome because of X, Y, and Z, as an expert, it's not your job just to take their conclusion, but to actually think about their reasoning. And that's why even if you didn't have a counter or a kind of a homologue expert on the other side, you could still say, but listen, that doesn't make sense. I'm not persuaded on the balance of probabilities that is the correct conclusion. And I think, I see people confuse sometimes the role of experts, but they actually have different roles. Sometimes it's that marshalling role where they kind of collect expert material and kind of in an expert way regurgitate it in a packaged way. Delay experts and quantum experts are often like that. And then at the other end of the spectrum, it's true that in very rare circumstances, you have a pure question of opinion. I just think that's the better way to do things, just based upon my experience without giving particular reason. But that's pretty rare. I'd say that most expert opinions give you a chain of reasoning as to how they get it. So to give you an example, I was doing a big case involving defective components for solar panels. And these solar panels have been used in lots and lots of installations. We were acting for the party who'd bought them from the manufacturer, and we were alleging that they were defective. So there was a root cause analysis, and the question was whether these solar panels had been used incorrectly or whether they had been manufactured incorrectly. So it was a root cause analysis. Now there, while you had different experts who had their opinions, they both had lots and lots of experiments and reasons why they said that it should be this or that. And so, I think that's more typical of even technical expertise. It's not just abstract opinion, but it's reasoned opinion. And that's half the battle.
So, and I've also seen some instances where the arbitrator gives up on both of them, or probably just, the tribunal gets lost in a lot of technicalities and says, now we want another expert. And then there's a tribunal appointed expert.
Mm-hmm.
Yeah, what does that usually mean when the tribunal goes for their own expert?
Yeah, I mean, that's difficult. I would say that it fits into one of two categories. I wouldn't, sometimes, some material is just beyond the grasp of lawyers. And sometimes through the no fault of the experts, the arbitrators, they can basically hit a comprehension wall. And that, I've only really seen that, I think, once or twice, where the material was it required so many building blocks to get to the point of understanding that I think the arbitrators legitimately said, we need somebody to help us unwind all of this.
Right.
More often than I would just say that the fact is that arbitrators have a greater or a lesser propensity to like certain technical material. So for example, some arbitrators are just allergic to numbers. They're brilliant jurists. They're brilliant in the forensic analysis of facts. Right. They just hate numbers. And sometimes they just say, well, I can't work this out because it's too complicated. Whereas I think other arbitrators would fall on the other side of the line saying, I'm happy to go through these accounts or these spreadsheets or this economic analysis.
Right.
So sometimes, yes, I say sometimes I think it's really, really legitimate. And sometimes I think it's just a preference not to deal with some certain things by arbitrators when you get a tribunal expert to resolve issues.
Fair enough. Let's come to timing. And I've really never been in a position where the expert really was in the room early than they were supposed to be. But it's something that I've heard, and it's something that I've read about being discussed, that how early is too early? Are you bringing them to support something, or are you literally outsourcing strategizing to experts? So how early is too early?
Well, I don't think it's too early. I think that there's just a cost-benefit analysis, to be honest. Because, for example, one role that independent experts can play if you bring them in early is to do kind of an initial opinion so that the party knows the strengths of their case. And often, for example, that can play a role in whether the client actually wants to start arbitration at all. And because, there's probably varying degrees of confidence with which people have cases. I think that the psychological things like confirmation bias mean that quite often people barrel ahead with arbitration complete confidence that they're right, but largely that's partially, say, combinations of confirmation bias and various other factors. And in fact, an independent mind would probably tell them that they're not so right.
Right.
I think more sophisticated clients sometimes are keen to make sure that they're proceeding on the right footing. And so when experts are involved really early, I actually generally find that it's less for the use of the expert as an independent expert in the arbitration, although they would use them subsequently, but just to get a feeling for the strength of their case.
And on the other side of the spectrum, I know this gentleman who's an expert, and I don't have his permission right now, so I would have used his name, but he said he was doing a delay analysis, and he said, I came in so late, it's almost archaeology at this point of time. So yeah. So what would we say if we were to come out with a guidebook? What would be the correct time? You said it's never too early. So
Yeah, exactly. But as I say, I think it's a cost benefit analysis, because the earlier you bring them in, the more you have to pay. But I think that if you're bringing them in, if you're bringing an expert in just for the purpose of proving your case in an arbitration, I think you need to work backwards from whenever their report would be submitted, and basically ensure they have enough time. Because I think one of the things is that if you put the expert under too much pressure to do their opinion in a relatively quick time, you'll get a cheap report because they'll have less time in which to build their time, but you'll get what you paid for, in the sense that the product won't be as good. And I think that's something that is important to properly brief an expert, to have proper discussion and to talk about, the materials they should review, the materials they shouldn't review, whom they should speak to, assumptions that they should make. Drafting a good quality report, it's time consuming. Of course, how long is time consuming to do a proper report, or how long is needed to write a proper report, obviously depends upon the subject matter. If it's a very short report and doesn't require a lot of background, it can be very quick. If it's, for example, if you take something like a power plant, and it's a delay report about that could be a hugely time-consuming process, and could require, lots and lots of document collection by the expert, lots of liaison between the expert and the project team to truly understand what happened and what delayed the project. And so, yeah, it's hard to say, except for the fact that I think that trying to save money by bringing in experts too late is, in most instances, a mistake that will kind of come back to haunt you.
right. And as my good friend said, probably look like archaeology, trying to save something which is dead.
That's right.
So then let me ask you this, that to somebody who's new in this profession, what are you going to say for a counsel, that what should be their do's and don'ts? What are the common pitfalls that they really need to avoid when they have to appoint an expert?
Yep. Okay. So I think the first thing is, when choosing an expert, you really need to do your due diligence, because getting an expert, getting the right expert is critical. If you get the right person, then that's half the battle. But to do that, you need to do a few things up front. One of the first things, of course, and this is something you definitely cannot do with an arbitrator, but you can do with an expert. You do need to be confident they will actually agree with your client's view of the world. Right. So you can very upfront say, listen, this is the approach that we're taking. Is this something that you could support? So you need to do that. That's one thing. The second thing is that I'm a big believer that you can't just interview an expert and look at their CV and get a feeling for whether they're any good. I think that in India, the legal community, people do tend to know each other. And what I'm a big believer in actually getting references from other lawyers if I haven't worked with an expert before. And so if I don't know people who've worked with the expert, I will ask that expert, who have you worked with? And I'll try to identify somebody who I know personally, who I trust, and I will have a call with them, and I will really say to them, listen, I really need to know, about this expert, because obviously every expert will tell you that they're wonderful, but that's because they're selling a product. And so, and maybe they're charming and nice, but the question is, do they have the skill set? Do they, in terms of the underlying expertise, as I mentioned, the ability to write and the ability to testify? Yeah, and not many people have those three things. A lot of people will fall down on one or the other. So, for example, maybe they don't write well, but they're good at hearings. I've definitely know some experts who fit into that category.
Right.
But the opposite could be true. It could be somebody who, is gets very nervous on the stand and kind of bumbles and doesn't come over as confident. There's also an issue that I think you need to get referees on is whether they manage their time properly. Because some of the best experts in certain disciplines are also the busiest because they're the best. And some people are very, very busy, but when the rubber hits the road, they organize their time well, they have a good team, they're kind of quite organized, and they still manage to produce good material despite being busy. Some not so much. I've had a lot of problems with some experts in the past. I've usually only worked with them once, where everything looked good, but they were too busy. And at the end of the day, I didn't feel that they were dedicating the right time to the matter. And, sometimes the drafts that they were sending us of their reports were kind of a bit half-hearted. So, just like with arbitrators, availability is an issue. Experts that can equally be an issue. So I think, so my advice to a first time would definitely be, don't just interview somebody and go, oh, yeah, you look good, you have a nice website and you come over well in an interview. Pick up the phone and start working through the the Indian friend circles in Delhi and Mumbai or wherever you are, kind of trying to get your kind of a third party opinion on how good the expert is.
Those are great tips, and those are very customized tips. So thank you for those. Let me just ask you: Has it ever happened in your experience that you've got a great expert, or you were witnessing a great expert who could not perform when it came to hot tubbing, or just was not really good with confrontation and did really badly when it came to hot tubbing?
Yes, definitely. And that can often arise, because I think realistically, I think that most experts fit into one of two categories, which is, professional testifying experts and then non-professional specialist experts. So if you've got someone like an accountant for damages, you really would expect that it's somebody who's done it before. And those people you normally don't have that phenomenon with, because if they didn't like testifying, they probably wouldn't do it. They would be an accountant or an auditor or something like that. They usually are pretty good. Where I've experienced that is when I've had a highly specialized subject matter where you need somebody who really knows something. And sometimes those people are simply just not good public speakers, or they don't like that. So to give you an example, I was doing a case once in Russia. And it was interesting because it was basically a European manufacturer of some very specialized factory equipment who was building a plant in Russia. And there was some challenges basically taking this Western European design and changing it for to Russian design standards. And basically the whole subject matter of the arbitration was whether this was possible with this technology. So it was quite technical. It was about an abandoned project. And so we found this brilliant Englishman who spoke perfect Russian and had done this many times, but he'd never been a testifying expert before. And it was very challenging because he was quite a shy, very technical engineer. And he just, when we practiced cross-examination questions, you'd say, oh, you say this, but that's not right. And he'd say, oh, yeah, that's probably not right. I was like, no, you can't say that. You can't just backtrack on your opinion that you've expressed. But he said, and so he just didn't like confrontation. So yeah, that can be a real challenge. And sometimes that's unavoidable because sometimes, as you say, if you need a really specific technical thing, you have to take the expertise with whoever the person is. And you just have to find ways to, he actually ended up doing fine for the record. But we had to kind of talk with him a lot and workshop through this, not to change his opinion, but just to make sure that he really kind of could convey his opinion without getting beaten up too badly.
No, that makes sense. That's a great story. Are there any tips for preparing, or do you give some kind of a brief to the expert as the counsel?
Well, that is a challenge because I think that there are around the world, there are very different views from a kind of a legal ethical point of view about the preparation of experts and witnesses.
Correct.
And I think at one extreme you have, some of the traditional common law countries where it's really unseemly to prepare experts or witnesses.
Right.
And then ironically, the other part of the common law world in the United States where it would be kind of malpractice if you didn't prepare your witnesses really thoroughly.
Right.
And that's kind of challenging because, as I say, you want to keep on the right side of those lines. And there are good reasons why lawyers are discouraged from preparing experts and witnesses. But as somebody who kind of exercises at a very international plane, as a general matter, I do, and it's for a very good reason, and I'll explain my own kind of philosophy of this, which is the idea of cross-examination is a little bit unfair in some circumstances because you have a professional questioner and an amateur witness or an amateur expert. And sometimes that's kind of unfair because somebody knows the rules of the game very well and how to play it, and the other person doesn't. And what that can sometimes lead to, and I see this as arbitrated too, is where somebody who's genuinely telling the truth or genuinely giving his or her honest and best opinion, who still kind of gets tied in knots by a skillful cross-examiner. So my philosophy is if it's a professional expert, like an accountant or a delay expert, I generally don't have to do anything or very little because I think, well, they know the rules of the game. It's fine. If it was like the type that I described before, where it's very much an amateur expert, I think that it is fair to kind of really take them through and explain the nature of cross-examination and not try to change their opinion or twist it in any way. I think that's really important. You don't do that because that's not what is good for the client. You really want a genuinely independent expert, but to kind of at least somehow even the playing field by, teaching them the importance of, for example, giving short answers, listening to questions carefully, not falling into traps of making undue assumptions, lots of things which a good cross-examiner will lead you into a trap for. And again, not to change their opinion, but just so they actually can get over their opinion fairly under pressure.
Yeah, true. We once took some industry expert for a very niche industry, and he was an extremely humble person, and he was the only one who knew that industry so well, but he was really humble. So when he was being cross-examined and the other side's counsel told him that, I don't think you have enough information on this. I don't think that, the questions were just insinuating that he doesn't know enough. And he was just so humble, and he said, maybe I don't. And
honestly, I think one of the I've shared that experience, and I think one of the problems there is the scientific methods that real scientists are looking at this kind of objective truth. And I had that experience with a German expert in the burning of coal, and he was extremely technical expert from Western Germany, world authority on the exact chemical behavior of coal when it burns, and so very, very technical expert, had nothing to do with this. Now, the issue there is that a scientist is always interested in being challenged because if you prove them wrong, they're like, oh, this is great because now I know more about the field, and it kind of lifts our knowledge of the field. And scientists, you're often very, very modest about the world, very different to lawyers, who are usually vehemently convinced that they're right on every single point because that's their job.
Right.
And so that is that I've shared that experience, and that's it's a challenge because, as I say, you have this kind of clash of philosophies about objective truth and how you discover it. Because one is just interested in winning and the other one is interested in finding out the truth. And those two things don't necessarily, they don't manifest in the same way.
I'm glad that you think so and that you sit as an arbitrator. That means that you keep all this into perspective when you're deciding. Because sometimes, our heart sinks when we see a great expert unable to face a cross-examination effectively.
That's a good point. And as arbitrator, it's not your job to unduly protect an expert or a witness, for that matter, from good cross-examination. That's something you have to accept as part of the game, for the most part. But I, for one, when I'm sitting as arbitrator, I think that most good arbitrators are focused on what's relevant to deciding the case, and I think that quite often cross-examiners, focus on things like, qualifications and some points of credibility with experts, And more often than not, that's that type of material. Okay, maybe you can beat up a witness or an expert and make them look bad, but at the end of the day, when we're back in the hotel room as a tribunal discussing the matter, usually not what we talk about. We normally talk about the subject matter. What matters is is the opinion incorrect or is it correct? Yeah.
Music to our ears. So I think we've got some great takeaways from you. We have the time, we have the qualifications to look for, we have the tips on calling our entire Indian family and getting a background check as we usually do, and we have the key tips for preparation too. So I think this has been useful. And
Well,
yeah, where else would I get to go get those tricks of trade from you? I'm really happy.
well, Abhisaar, it was a pleasure, and as I say, it was wonderful questioning, and as I say, I'm extremely grateful to the ICC India for inviting me to speak to this today, which is a topic which I think is extremely important.
Thank you.
Thank you so much, Dr. Secomb. Thank you so much, Ms. Bairagi. That was a very insightful episode, and we really thank you, and it was an absolute pleasure to have you both with us today. We definitely intend to have much more and much more insightful interactions with you in the future. And that's it. That's a wrap for today.
Definitely. Thank you.
Thank you.